Imagine waiting years for your child to immigrate, only to be told they've aged out and are no longer eligible. It happens more often than you'd think. In the U.S. immigration system, a child is someone under 21. But slow government processing causes many kids to turn 21 before their green card is ready. That's where the Child Status Protection Act, or CSPA, comes in. It's a legal safeguard that helps preserve a child's immigration status, even after turning 21, if certain conditions are met. Today, we're breaking it all down. Who qualifies? How the age is calculated. What forms to file. And what to avoid. Let's get started. So, what exactly is the Child Status Protection Act? Passed in 2002, the CSPA was created to prevent children from being kicked off petitions just because of government delays. Under normal rules, a child who turns 21 before getting a green card could lose eligibility, or be pushed to a less favorable visa category. But with CSPA, their age can be frozen or adjusted, giving them a real shot at staying eligible. Who benefits? Children of U.S. citizens and green card holders. Derivative children of employment-based applicants. Children of refugees and asylees. And even those in humanitarian programs like VAWA or the Diversity Visa Lottery. Let's say your green card was approved after 5 years, and your child is now 22. Under CSPA, you may be able to subtract the petition's pending time and keep them in the child category. Think of it like hitting pause on your child's immigration age. But eligibility depends on your case type. Let's go over the main categories. First, family-based petitions. If the petitioner is a U.S. citizen and the child is under 21 at the time of filing, no calculation needed. They're locked in as a child. But if it's a family preference case, like F2A, you'll need to calculate the CSPA age and prove the child sought to acquire a visa within 1 year. Second, employment-based petitions. Children listed as derivatives must also calculate their CSPA age and take action within 1 year of visa availability. Third, refugees and asylees. This group gets strong protection. A child's age is frozen at the time of the initial asylum or refugee filing, no calculations, no need to prove anything extra. And finally, humanitarian cases. CSPA protections also apply to children of diversity visa winners, T or U visa holders, and VAWA applicants. But rules vary, so check the details for each category. Now, let's dive into the most important step, calculating the CSPA age. Here's the formula. CSPA age equals age at visa availability, minus time the petition was pending. Step 1. Determine the child's age when the visa became available. Step 2. Subtract the amount of time the petition was pending, from the day it was filed to the day it was approved. Example. A petition is filed when the child is 17. It takes 3 years to get approved. When the visa becomes available, the child is 22. Now subtract the 3 years it was pending. 22 minus 3 equals CSPA age of 19. That child is still protected. But there's a catch. Once the visa becomes available and the CSPA age is under 21, the child must take action within 1 year. This is called seeking to acquire lawful permanent residence. That could mean filing Form I-485, submitting the DS-260, or even having a lawyer send a formal intent letter. Waiting too long could mean losing CSPA protection. Next, let's look at the forms and documents you'll need. You'll need Form I-130 or I-140 to show petition filing and approval dates. Form I-485 or DS-260 to apply for the green card. Form I-797 notices to confirm receipt and approval. Birth certificate to prove parent-child relationship. You should also include proof of visa availability from the Visa Bulletin. A breakdown of your CSPA age calculation. Evidence that you acted within 1 year of visa availability. What if your case gets denied? You may be able to file a motion to reopen or appeal to the Department of State. Courts have ruled in favor of applicants who meet CSPA criteria but were unfairly denied, so don't give up. Now, what's new in 2025? Recent cases like matter of VAS clarified that you don't always need to file a form. Showing timely, documented intent may be enough. Another case, Singh versus Garland, backed up children on employment-based petitions who were wrongly denied. USCIS also reminded officers to accept a wide range of documents and consider exceptional circumstances when the one-year deadline is missed. But beware of visa retrogression. If your visa category moves backward before you file, CSPA may not protect you, unless you already filed or have other factors in your favor. Timing is everything. Let's look at a real-life story. Ahmed filed for his daughter Lena when she was 19. The petition took 3 years. When the visa became available, Lena was 22, but her CSPA age was 19. She filed her DS-260 within 3 months, and now lives in the US. Another example. Gloria was granted asylum. Her son Miguel was 20, but his age was frozen based on the filing date from years earlier. He entered safely in 2024. But not every story has a happy ending. Priya filed for her stepdaughter Anika, but waited more than a year to submit the I-485. Even though she was under 21 when the petition was filed, she missed the seeking to acquire deadline. The case was denied. Let's close with the most common mistakes to avoid. Number 1. Missing the one-year deadline. Number 2. Reading the wrong chart on the visa bulletin. Number 3. Assuming you're automatically protected. Number 4. Failing to document your intent. Number 5. Filing too late after retrogression. And number 6. Forgetting the special rules for adopted or stepchildren. Bottom line. The Child Status Protection Act is a lifeline, but it only works if you follow the rules. Calculate your age correctly. Act fast. Document everything. And if you're unsure, get legal help. Your child's future might depend on one timely form. Thanks for watching, and stay informed.